Hi, I'm Tanya Patterson with the Indiana Civil Rights Commission, and I'm an investigator in the Employment Unit, and today we're going to go through the civil rights laws. The applicable laws to the Civil Rights Commission are the Indiana Civil Rights Act and Title VII of the Civil Rights Act of 1964. Keep in mind that Indiana is an Atwill State. An Atwill State simply means that Indiana follows the common law doctrine, which dictates that employment relationships are at will rather than a fixed term. In other words, an employer can terminate your employment for any reason whatsoever, as long as it's non-discriminatory. As a matter of fact, an employer does not even have to have a reason to terminate your employment. There are certain exemptions to being an at-will state. Exemptions include employment discrimination, retaliation, and violations of Indiana's public policy. There are 7 protected classes that are covered under the civil rights laws, and those classes are race, religion, color, sex or gender, disability, national origin, or ancestry. So who is covered under the civil rights laws? Well, for the Indiana civil rights laws, then an employer only must employ 6 persons or more, and on the federal level, then there's a requirement of 15 or more employees. An employee does not include any individual who is employed by his parents, spouse, or child, or a person employed in the domestic service of another person. Now, there are exceptions. Some entities are specifically exempt from the Indiana Civil Rights Act. Those exceptions include a nonprofit corporation or association that is organized exclusively for fraternal or religious purposes, any school, education, or charitable religious institution that is owned or conducted by or affiliated with a church or religious institution. And lastly, any exclusive social club, corporation, or association that is not organized for profit. There are many areas that are covered under the civil rights laws. They are hiring and firing, compensation, assignment, or classification, transfer, promotion, layoff, or recall, job advertisement, recruitment, testing, use of company facilities, training and apprenticeship programs, fringe benefits, pay, retirement plans and disability leave, and other terms and conditions of employment. What is a discriminatory practice? These are practices that include such things as harassment on the basis of race, color, religion, sex, national origin, disability, or ancestry, retaliation against an individual for filing a charge of discrimination, participating in an investigation, or the person opposing discriminatory practices. Employment decisions based on stereotypes or assumptions about the abilities, traits, or performance of individuals of a protected class, and denying employment opportunities to a person because of marriage to or association with an individual of a protected class. Recently, the Civil Rights Commission investigated a complaint where an employer advertised for female only for a position. This is an example of overt discrimination. An employer cannot advertise for a specific gender only for an available position. The Act prohibits not only intentional discrimination, but also practices that have the effect of discriminating against individuals because of their membership to a protected class. This is also called disparate impact. An example of a disparate impact case would be when a grocery store requires all employees to be able to retrieve carts from the parking lot. This is a clear example because it would severely impact those that have a physical disability and would not be able to retrieve said carts. As discussed earlier, national origin is also a protected class that is covered under the civil rights laws. It is illegal to discriminate against an individual because of their birthplace, ancestry, culture, or linguistic characteristics common to a specific ethnic group. An employer cannot have a rule requiring that employees only speak English unless it is necessary to conduct their business. The Immigration Reform and Control Act of 1986 requires employers to assure that employees hired are legally authorized to work in the United States. However, this does not allow employers to request employment verification from just one national origin. It must be collected from everyone. What is retaliation when it is pertaining to the civil rights laws? An employer may not fire, demote, harass, or otherwise retaliate against an individual for filing a charge of discrimination, participating in a discrimination proceeding, or otherwise opposing discrimination, which applies to Title VII only. Another covered area under the civil rights laws is protection of discrimination from religion. Employers may not treat employees or applicants more or less favorably because of their religious beliefs, except to accommodate their religious beliefs. Employers cannot refuse to hire people of a certain religion, impose stricter promotion requirements, or different work requirements. Employees cannot be forced to participate or even not participate in a religious activity. The Civil Rights Commission recently went probable cause on a complaint that involved a Muslim complainant. This complainant had a tendency to write down random notes whenever he had a random thought. He happened to leave some of these notes in his company vehicle. The respondent, when cleaning out the vehicle, saw some of these random notes that included news clippings, such as bombings. Respondent terminated the employee and stated that it was because the employee made threats against the employer and employees. This was not the case. The employee was just making down notes of recent news events. Now, there are instances when an employer is not required to accommodate an employee's religious needs. An employer is not required to provide an accommodation if doing so would impose an undue hardship on the employer's legitimate business interest. Legitimate business interests are things such as causing more than ordinary administrative cost, if it diminishes efficiency of other jobs or employees, if it impairs workplace safety, or conflicts with another law or regulation. The next area of discrimination that I would like to talk about is sex discrimination, also known as gender discrimination. Sexual harassment is an area of sex discrimination, and sexual harassment involves practices ranging from direct request for sexual favors, which is also known as quid pro quo, to workplace conditions that create a hostile environment for persons of either gender. The hostile environment standard also applies to harassment on the basis of race, color, religion, ancestry, and disability. The Commission ruled probable cause on a complaint recently that involved a complainant who was receiving different sexual messages on her cell phone, although the complainant reported that she no longer wanted to receive these messages. The employer did not do anything to prohibit her from receiving these messages. Another area of sex discrimination is pregnancy-based discrimination. Pregnancy, childbirth, and the related medical conditions must be treated in the same way as any other temporary illness or condition. There are additional rights that are available to parents and others under the Family and Medical Leave Act. For more information about FMLA or to file an FMLA complaint, individuals should contact the nearest office of the Wage and Hour Division, Employment Standards Administration of the United States Department of Labor. The next area of discrimination that I would like to cover is race discrimination. Equal employment opportunity cannot be denied to a person because of their racial group, their perceived racial group, any racial linked characteristics, or their marriage or association with someone of a particular race. The Act strictly prohibits discrimination regardless of whether it is directed at whites, blacks, Asians, Latinos, etc. The civil rights laws prohibit discrimination and disability in all areas of employment. It is necessary to understand several important definitions to know who is protected by the law and what is illegal discrimination. So who is disabled? An individual with a disability under the Act is a person who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded as having such an impairment. Major life activities include walking, breathing, seeing, hearing, speaking, learning, and working. A qualified employee or applicant with a disability is someone who satisfies skill, experience, education, job-related requirements, and is able to perform the essential functions of the job with or without a reasonable accommodation. An employer does have a duty to accommodate in specific situations. Reasonable accommodations may include making facilities accessible, job restructuring, modification of work schedule, additional unpaid leave time, reassignment to a vacant position, acquiring or modifying equipment or devices, training materials, or even policies, and provide qualified readers or interpreters. Disabled individuals should have the ability to enjoy the benefits and privileges of employment that are enjoyed by those people without disabilities. Now, what is undue hardship? An employer is required to make reasonable accommodations for a qualified person with a disability unless doing so would cause an undue burden, significant difficulty, or expense considering the business size, financial resources, and the nature and structure of the operation. Before making an offer of employment, an employer may not ask job applicants about the existence, nature, or severity of a disability. However, applicants may be asked their ability to perform the job functions and to have a medical examination, only if this examination is required for all entering employees in the same job category and related and consistent with business necessity. There are always questions regarding illegal drug and alcohol use and whether or not those individuals are considered disabled. Employees and applicants currently engaging in illegal drugs and alcohol are not protected by the Act when an employer acts on the basis of such use. Drug tests are not considered medical examinations and therefore are not subject to the Act's restrictions. Employers may hold individuals who are illegally using drugs and/or excessively using alcohol to the same standards of performance as other employees. It is important to remember that the civil rights laws protect both potential and current employees from discrimination in employment. It is unlawful to discriminate against a person because of their protected class or their association with a person who is a member of a protected class. While individuals always have a right to file a complaint when they feel they've been a victim of discrimination, the Civil Rights Commission, pursuant to public policy, also protects employers from unfounded charges of discrimination by performing neutral investigations. If you ever have any questions about the civil rights laws, please do not hesitate to contact the Civil Rights Commission at 100 North Senate Avenue, room N103, Indianapolis, Indiana, 46204. The office phone is 317-232-2600 or toll-free 1-800-628-2909. For those hearing impaired, 1-800-743-3333. Or feel free to visit us on our website at www.in.gov/ICRC. Thank you very much.